Before I read this paperwork, you need to understand something. This is not a motion. This is not a complaint. This is a federal declaration filed from inside the jail under the penalty of perjury. And in this paperwork, Big, you was telling the judge that the government took his defense, isolated him, and made it nearly impossible for him to prepare for trial. But here's the part nobody is talking about. He's not even asking for more time. Nah, he's asking for something way more dangerous, because once this is on the record, it never comes off. And by the end of this video, you're going to understand why this filing matters, even if he loses every single motion. Y'all ready for this one? Good 20-minute video before you head to bed. Let's go. Hit that like button like you like something too, please. So what we're going to do is we're actually going to jump around on a couple of pages. We will not be reading the whole entire thing. I know there's probably lots of cheers and all that stuff going on, but it is what it is. So y'all can see this is Big U. And basically what he wrote is, Defendant Eugene Henley Jr.'s submission of letter and declaration regarding conditions of confinement and their impact on his ability to participate in defense preparation. Dear Honorable Fernando L. Alena Rocha, I'm just going to say Rocha, yeah. District Judge, I respectfully submit this letter and enclosed declaration for the court's awareness regarding conditions that have both existed and newly developed during my pretrial detention at MDC Los Angeles, and the ways in which those conditions have affected my ability to review discovery, communicate with counsel, and meaningfully participate in the preparation of my defense in this case. It is important to me that the court understand that I am not filing a motion and I am not requesting a continuance or additional delay in these proceedings. In fact, absent being granted bond, I will always assert my speedy trial rights. The purpose of this submission is to provide the court with an accurate record of my circumstances, including events that occurred after my original detention hearing, and explain how those conditions affect my ability to exercise my constitutional rights while my case is pending. The enclosed declaration describes in detail the placement in administrative detention, the seizure and non-return of my legal materials and discovery, USB limitations on discovery access, interruptions in medical accommodations, continuing legal mail issues, the investigative hold on my trust account, and the failure to carry out a prior court order relating to the death of my son while I have been in custody. Oh, wow. I have also described the steps I have taken to raise these issues internally and through institutional channels. My intention in submitting this letter is that I am asking the court to be aware of these developments and the impact they are having on my ability to participate in my defense, and that the court consider any relief or guidance it finds appropriate. Aside from continuing trial, I reaffirm that I am not asking the court to delay the case. I am trying to move forward and to participate meaningfully, but under the conditions described in the declaration, I do not have a realistic ability to do so. Absent intervention, this court deems necessary. If the court believes a hearing, clarification, or further submission from counsel is appropriate, I will, of course, defer to the court's decision. Thank you for your time and consideration. Respectfully submitted, Eugene Henley Jr., defendant, dated January 4th, 2026. In the easiest ways and terms necessary, basically all he's saying is, bruh, how am I supposed to get ready for trial when literally y'all keep on doing all this messed up ass stuff? Y'all screwing me over. Y'all ain't even adhering to what we had already agreed to. And I wonder what the hell happened with his son. Is he going to say that they didn't allow him to basically go to the funeral virtually? I don't know. But what I do know is, boom, we got that app now. Yeah. Fast Cash got that app, bro. Y'all been killing it. So the easiest way to get on the games, and you ain't got to scan the QR code and all that crap every time, is scan this QR code or tap the link in the description so you can get the app. And when you do, I'm going to give you $5. Yeah, hot $5. They're going to automatically, once you sign up, boom, they're going to put $5 in your account already ready to go. Go and win. Nobody's calling this crap a scam. Hell, Drake can't even say he did that. Drizzy. But anyways, let's continue on with this Big U paperwork. It does get intense. Roll it. Failure to follow court order. As this court is aware, while I've been detained in this case, my son was murdered. Losing my child while I am in custody has been amongst the most challenging experiences of my life. In connection with my son's passing, the court issued an order related to my ability to have contact or participation. Despite that order, I was not permitted the contact or participation that the court intended. The order was not followed. I was not able to be present for my son in the way the court had authorized and made an exception after his death. I was not allowed private viewing, even though there was a court order for this. Of course, I will never have that opportunity again. This has caused my family extreme grief and distress. It also affects how I experience my detention. I'm trying to process the death of my child while at the same time being asked to assist in a complex RICO defense with almost no access to materials or pertinent discovery. The failure to follow the court's order about my son's death has also affected my confidence that any institutional promises or any future accommodations will actually be carried out, with or without a court order. When a court order concerning a matter as serious as the death of a person's child is not honored, it is very hard for me to trust the less formal assurances about discovery or access will be respected. As I continue to grieve my son, the combination of that loss, the unfulfilled court order, and the conditions described below directly affects my state. Legal mail problems and access to case documents. During my time at MDC Los Angeles, there have been ongoing problems with my legal mail. Based on what my attorneys of record have told me, I understand that approximately 25 pieces of legal correspondence were extremely delayed or never reached me at all. I am informed by my attorneys that some of those mailings were even sent with tracking. On multiple occasions, legal mail has arrived to me already open, so of course not open in my presence. On other occasions, I've been told mail was sent, but I never received it. These problems have involved important materials such as my indictment and other case documents or legal notes. I believe between 1 and 3 legal professionals can and would declare to the same. For a long period of time, I did not have a complete copy of my indictment, even though my counsel tried repeatedly to send it. I did not actually obtain a copy of my indictment until December 2025. On January 1st, 2026, when I was suddenly and abruptly moved to special housing unit with zero knowledge as to a reason why, I lost access to my indictment and other legal papers. At an earlier detention proceeding, the government referred to recorded calls and to issues related to legal mail, although they are allegedly a completely different entity than MDC. That caused me to be concerned that communication connected to legal matters might have been accessed or shared in ways I did not understand. As a result, I become hesitant about freely discussing case strategy over the phone. I have submitted numerous cop-outs, emails, and formal grievances about my missing or mishandled legal mail, and I have raised these issues verbally with staff, including at the highest levels. The general response has been that there is no problem, with the notable exception of Officer Reyna and Delgado on an email actually acknowledging that one item of legal mail was open outside of my presence: seizure of USB and legal work product. On January 1st, 2026, I believe staff conducted a search of my cell and my property. During that search, they took my USB drive that contained discovery materials provided by my attorneys, as well as my handwritten legal notes, drafts, research, and other defense work product. To my knowledge, the USB and those legal materials were not inventoried. When I asked about them, staff had not acknowledged that they exist or that they were taken. Although my attorneys still possess copies of discovery in their own files, the seized handwritten materials reflected my thought process, questions, and observations developed over prior meetings. Without those personal defense notes, I cannot meaningfully build upon earlier discussions or recall what issues I had already raised or identified. Having counsel retain their own copies is not a substitute for my ability to retain and reference my own defense work product while assisting in preparation. The papers that were removed were clearly labeled as legal mail or attorney work product. They contained my notes about what my lawyers had explained to me, thoughts about the evidence, and questions I have written down to discuss with counsel. On January 2nd, 2026, I telephonically notified my attorney, Peter Johnson, about my shoe conditions related to legal documents as well as health topics. I also let him know I would be submitting a letter directly to you about various topics, to which he did not object. The USB contained approximately 500 non-protected discovery files provided to me from my attorneys. However, almost all of my most important discovery in this case is under a protective order. That protected material can only be reviewed when my defense team is physically present. The seizure on non-return of my USB and legal items, including handwritten legal work, has cut off my ability to continue any of the prior work I had done to understand my case. I cannot go back to my notes, cannot track what we have already discussed, and cannot build on earlier sessions. In practical terms, I am forced to start over with almost nothing in my hands. Shoe placement and legal investigative status. Also on January 1st, 2026, I was moved to special housing unit at MDC Los Angeles. Lil Durk is my other cellmate. I was told this was administrative detention and that the stated reason was classification. I did not receive any incident report, disciplinary write-up, or hearing related to this move. To my knowledge, there was no finding that I committed a disciplinary infraction that required shoe placement. Since being in shoe, my ability to meet and consult with my counsel becomes much more limited as as this district is well aware. Due to several attorney filing motions about this, legal visits require additional escorting and approval and have non-reported or advertised additional time constraints. There are, therefore, more delays and more uncertainty about when and how visits can occur. My access to legal materials in my cell is also more restricted. The combination of shoe placement, investigative status, and the removal of my USB and notes has made it extremely difficult for me to in the future have normal attorney-client meetings or to review materials in a continuous, organized way going forward. Contrary to what I anticipate to be characterized as a challenge, I am describing the practical effects of this placement on my ability to participate in my defense. Now listen. I know there are people who are, talking shit and all this stuff and everything, and some would call it karma, which, once again, I don't believe in. So if you're one of those people saying, well, Big, you 100% guilty of murdering somebody else's child. So I find it interesting that that your son got murdered, and now you can't go see him because they can't see their child grow up. So you get what you get, and you only are there because you murdered somebody's child. If you one of those people, then it is what it is on that. Do I know or believe that Big you murdered that boy? I have no goddamn idea. I wouldn't put nothing past nobody. I'm just going to be fair, square, obvious, and honest. Do I think he did it? I hope to God he didn't do it. I really hope he didn't do it. But if there is evidence that it shows that he did it, then shit, buck up, soldier. But here's the worst thing. The guards are ignoring the orders of everything. They had this crazy saying to say, the inmates are running the prison. Well, them guards making sure they keep their foot on their neck. And even if you believe that Big U doesn't deserve rights and all this stuff and you already found him guilty, the thing is this. We still have laws that keep us from becoming like those who you believe should basically be held in prison for however long y'all may think they do. I'm not here to discuss that with y'all. But what I am here to say is this. They dead ass wrong. It's your job, not your feelings. See, everybody who would say anything negative or positive towards Big U, the ones who say whatever they want to say, you can use logic and all that, and you can use feelings. But a guard is not afforded that. A guard is a dog. You do what you told, and you get your treat, a.k.a. your money, regardless of personal feelings. So they probably going to fire back and have to say, yo, Big U was raucous and all of this shit and everything and didn't want to do this and didn't want to do that. They're going to fire back because they have to. Because if this is true, bruh, this ain't good. Let's continue on. We'll read all the way to page 11 on this and we'll call it a day. Including restricted attorney access, loss of materials, and interruption of previously authorized accommodations. Regardless of the institution's reasons for placement, my resulting restrictions materially affect my ability to prepare my case. Medical, chrono, and loss of CPAP. So he already had it in other accommodations. Okay, so before, or maybe he didn't. I don't know. Let me read this because I don't want to say this wrong. Before coming into federal custody, I was prescribed a CPAP medicine for sleep apnea. MDC medical staff issued a Bureau of Prisons medical chrono authorizing use of CPAP machine. Okay, cool. A knee brace and a 2-mattress accommodation. I also wear prescription glasses. After I was moved to SHU on January 1st, 2026, my CPAP machine and plug were taken. I was allowed to use the CPAP briefly, but when it was taken away again, since that time, I have repeatedly requested that it be returned and have explained that I am worried about serious health conditions if I go without. Put frankly, Death can occur for those who require breathing machines when they sleep if they do not have one. Therefore, since being in the SHU without it, I simply cannot allow myself to fall asleep whatsoever. Okay. My additional mattress accommodation due to back and shoulder injury and my eyeglasses have also not been provided in SHU. My knee brace was returned after a short period, but the lack of sleep support and proper bedding has made my physical discomfort worse. Without the CPAP and the full set of accommodations, I have trouble focusing and I feel physically worn down, as can be anticipated. That makes it much harder for me to concentrate during future legal visits or to review any materials I do receive. Trust account investigative hold and communication limits. This ought to be interesting. A $2,500 investigative hold has been placed on my inmate trust account. I was not given an explanation for why this hold was placed or what event or investigation triggered it. Such a hold is to hinder a person's ability to purchase commissary items such as food or hygiene items, and with the ability to use computer systems such as core links that I also rely on to coordinate regarding my defense when I was not in the SHU. Attempts to resolve these issues internally. I have tried to address these problems through the channels that are available to me. I have submitted multiple cop-outs. I have filed a BP-8 informal resolution and a BP-9 grievance. I have sent a grievance to the regional director. I have even contacted Postal Service about the mishandling of my mail. For some examples, I have raised these issues verbally many times with staff in my unit and with supervisors, including at the warden level. The general response has been to say that there is no issue or to not take any corrective action. As of the time of this declaration, the USB and legal papers have not been returned. My discovery access remains extremely limited. My mail problems continue, and my medical accommodations are still not provided. This is not a complaint about comfort, inconvenience, or general detention conditions. The conditions described are directly tied to my ability to see evidence, understand the government's allegations, and communicate with counsel in a continuous and organized way. In other words, these conditions affect the core constitutional right to participate in my own defense rather than day-to-day living conditions. Because my USB and notes were taken, and because I am in the SHU and under investigative status, I do not have ongoing access to discovery that would allow me to understand the government's evidence or assist counsel in developing strategy. The problem is not that there has been too little time on the calendar. The problem is that under these facts, conditions, and restrictions, there's no realistic way for me to prepare no matter how long this case is continued. You know, the way that reads actually kind of throws me off just a little bit. And I'm just being honest, right? Let's just say it wasn't Big U. It was somebody else. Let's say James B. James B. out of West Virginia. Let's just do James B. out of West Virginia. And James B. was accused of doing all of these things. And some of y'all like, bruh, I'm in Nitro, West Virginia right now. You cannot be talking about me. Or I'm in Charlotte. What is that place called? Anyways, I'm in West Virginia, bruh. You ain't talking about me, right? No, I'm not talking about you. But this is what I mean. If these things are right, they're sabotaging the hell out of him. And on top of that, that's illegal. If the doctor said that he's supposed to have this shit and they prescribed it to him, you give it to him. So everything that he has in the jail, he has access to it. And all of a sudden, just as his case is coming up, now y'all want to get rid of it. Which to me seems like either one, he was doing bad communication. Two, they were reading this shit and it sounded pretty good. And the biggest one, they're scared he might beat it. They can be afraid that Big U might have been putting in that work, might have been doing all of these things. Now, mind you, he cannot be around all of this discovery with all these people and all of these things without other lawyers present. But if he hasn't been sleeping, if he has been tired, if he's whooped, if he's in segregation housing unit, just like Lil Durk is, and it's even crazier because he asked for 2 more attorneys on the case, which if they took all his notes and all this shit, then damn near you want to do that. Now, will the judge grant the 2 attorneys? No, it might grant 1. 1 is better than none. It's just going to be fair, square, obvious, and honest. But all in all, we're going to see how this goes, because this is the second high profile case that we heard that involved quote unquote gang members, but Oh, we can't say because we ain't looked at nobody else's cases. But if this how I go for quote unquote gang members with murders and all of this shit and everything, bruh, I'm gonna be honest. This is a bad message because this shit better be going on with everybody. Don't just make this a gang member thing. Because if it does, then that's a big ass lawsuit. Not only that, he looking at an appeal too. Because you have to have the ability to defend yourself as best as they can take care of you and as best as you can take care of yourself. If they're hindering that ability because it's their fault, the courts don't look on that lightly. So we'll see what happens. Y'all let me know. Do y'all think that that Big U deserves all his shit? Or do y'all think, man, you know what? Suck it up, Buttercup. Do y'all believe that? Which one do y'all believe? I believe personally, give him shit. Let the man defend himself. If your evidence is good enough and all this shit, it ain't gonna matter what the hell Big U doing. Big U should be getting ready to spend the rest of his life behind a cold cell. If that's the case. But to me, it's kind of screaming like, bruh, you pissing them guards off. Do I know that? Hell no. Nah. Would I talk to anybody about that? Hell no. But in my mind, this sounds like a struggle a little bit for dominance. And me knowing Big U as well as I do, shit, that wouldn't be far-fetched. But like I say, I ain't believe he can do no shit like this, but they got him on something, I guess. But how true that is, I don't know. Maybe he beats it, maybe he doesn't. If he beats it, then shit, he beats it. But we'll see what happens, man. If you like what we do over here, man, all breaking news and all that stuff, consider hitting that subscribe bell and let you guys know we are giving away PlayStation and Xbox at 300K. Be an active subscriber. That means like every video, comment on every video. We are 28K away from that giveaway. Other than that, I will catch y'all in the next one. I'll probably drop that Zion Williamson in like 2 hours. So I got to dig up something. It's a lawsuit on him. It's crazy. But keep caught up. Hit that playlist right there too. Or click right here to see how a Little Dark Day in court went horribly wrong.